So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started, eggs don't make me lay hands on you. Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the bailiff.
Not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me? Why are hands on you?
I told you I could put hands on you.
Nasir Brown. Are you Nasir Brown?
Ready in the meeting. I'm sorry. We've been here before.
You've been here before, but you have to speak up where I can hear you.
You execute beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. We were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
They didn't do it.
Who'd you talk to?
Made a few calls to the guy, wife. What's his name? Wife King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made it so.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to be, to go back and forth in front of a lawyer that's invested that I'm not fond of this is formal names.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter.
What we're watching here is a bond revocation hearing that escalates quickly into a physical confrontation. The judge had previously given Mr. Brown explicit instructions, apparently to retain counsel. And
that's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started, eggs don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the bailiff.
I am not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me? Why are hands on you?
I told you I could put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Put your hands on the wall, but you're not listening. Listen, I don't surprise that.
Blaine Dunnigan. Good morning, sir. Are you Blaine Dunnigan? And will your client waive the formal reading of the indictment?
It will, Judge.
See, Mr. Dunnigan, in clause number 25, DCCR 0566, you're charged with the 3rd-degree felony offense of driving while intoxicated, 3rd or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016, and after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yes.
And are those two prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country?
These two segments show standard plea colloquies, but with notably different outcomes. For Mr. Dunnigan, charged with felony DWI third or more, the judge walks through the constitutional checklist: voluntariness, competency, understanding of the appeal waiver, and the immigration consequences warning required under federal precedent. Notably, sentencing is deferred pending a pre-sentence investigation report, common when a probated sentence is being considered, since the court wants more background before finalizing terms. The Freddie hearing is more interesting procedurally. The prosecution catches a charging error mid-hearing, realizing the underlying probation was for a misdemeanor evading charge, not a felony as originally alleged. The court allows an oral amendment to the motion to revoke over no real objection. A reminder that revocation motions can be corrected on the record without restarting the process, as long as the defendant isn't prejudiced by the change.
Or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Never mind, Judge.
It's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
What about Felicia Freddie? Just go through the motion.
I mean,
I get pleased today and then reset it for sentencing.
so she's
Good morning. Are you Felicia Freddie? Speak up loud and clear so I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddie, in cause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that one.
We gotta put this down, it's my recollection.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a Class A or B?
Eluding state.
I'm not sure, Judge.
If I have a second, Judge, I can.
Here, I'll look at
Mrs. Smith says B.
Big papers. A. Of that motion, so everyone. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually played to the lesser included. Listen,
Any objection to that?
I don't mind the court, I'm amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good, thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a Class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. Say 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner, especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true? True. All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
Okay.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go. Just put it like that other one, make a note that I can find a date for it. Yes. Not an 11 o'clock, an actual day. There's 2 up. There was another one, right?